భారత న్యాయ వ్యవస్థలో కొత్త శకం ప్రారంభం కానుంది. నేర న్యాయ వ్యవస్థలో సమగ్ర మార్పులతో కొత్త నేర చట్టాలను కేంద్రం తీసుకొచ్చింది. ఈ చట్టాల్లో నిందితులకు శిక్ష విధించడం కన్నా బాధితులకు న్యాయం చేయడానికి ప్రాధాన్యం ఇచ్చాయి. జూలై 1 నుంచి అమల్లోకి రానున్న ఈ 3 చట్టాలపై అవగాహన కల్పించే లక్ష్యంతో హైదరాబాద్లోని కేంద్ర సమాచార ప్రసార శాఖకు చెందిన పత్రికా సమాచార కార్యాలయం PIB పాత్రికేయులకు వార్తాల పేరిట శిక్షణ శిబిరం నిర్వహించింది. నల్సార్ల విశ్వవిద్యాలయం వైస్ ఛాన్సలర్ శ్రీకృష్ణదేవరావు, సెంట్రల్ డిటెక్టివ్ ట్రైనింగ్ ఇన్స్టిట్యూట్ డైరెక్టర్ ఎన్ రాజశేఖర్ IPS, ఏపీ పోలీస్ మాజీ ఇన్స్పెక్టర్ జనరల్ ఈ దామోదర్ IPS ఈ శిక్షణ శిబిరంలో పాల్గొని ప్రసంగించారు. ఈ సందర్భంగా CDTI డైరెక్టర్ రాజశేఖర్ మాట్లాడుతూ కొత్త క్రిమినల్ చట్టాల్లో చేసిన మార్పుల గురించి వివరించారు. ముఖ్యంగా మహిళలు, పిల్లల హక్కులపై ఈ చట్టాల్లో ప్రాధాన్యం లభించిందన్నారు. ఉగ్రవాదం, వ్యవస్థీకృత నేరాలు, కనీస శిక్షాభావన, చిన్న నేరాలకు శిక్షగా సమాజ సేవను ప్రవేశపెట్టడం వంటి ప్రధాన మార్పులపై పాత్రికేయులకు అవగాహన కల్పించారు. ఆర్థిక నేరాలు, సైబర్ నేరాలను వ్యవస్థీకృత నేరాలుగా వర్గీకరించినట్లు రాజశేఖర్ తెలిపారు. మరిన్ని వివరాలు.
So I will go through the bird's eye view of all the 3 criminal laws. This one. First of all, I said that in the IPC it was scattered. Now offences against women comes under one chapter, chapter 5, because if you see IPC section 376, 353 like that, the offences has been scattered and though. Chapter 4 deals with the incomplete offences like conspiracy, criminal conspiracy, or attempt to commit an offence and all those things. Again, chapter 6 is the human body and all those things. After the Supreme Court judgment, the transgender is also added. Now we have 3 genders. One is the male, female and the transgender, and the definition of the child has also been changed. Earlier, there you can see in 376 rape cases, rape of a minor below 12 years, minor below 14 years, like this, all these things were there. Now, child means male or female below 18 years of age. This is useful in section 72, that is the gang rape also. Now, gang rape again, rape of a minor that is below 18 years of age and above 18 years of age. Below 18 years of age, death penalty is one of the punishment. Of course, imprisonment for life is there. Above 18 years of age, that is the major women gang rape, then one of the minimum punishment is that is 20 years of imprisonment. So one of the new concept is the concept of minimum punishment in this new criminal laws. So it is of course it is the surety of the punishment, not the severity of the punishment. Sometimes it matters, but this is one of the things that is the minimum punishment has been prescribed in this one. So in case of cyber crimes, if you see, many of people like Chinese app loans load this one, they create an app in China and commit an offense in India. So section 48 has been brought out where an abatement made outside India for an offense to be committed in India is now punishable. And also there are 3 major offenses that has been added in the Bharatiya Nyaya Samhita. Section 111 is organized crime. Organized crime. So but all organized crimes are not same. That's why they made another one, this one, that is section 112, petty organized crime, like tickets, block tickets, movie tickets, selling of the question papers of the examination. So these all comes under the petty organized crime. And also section 113 is terrorist act, isn't it? See, if you see another one thing, section 124A, that is sedition, has been repealed now. Because earlier sedition means if you talk or if you publish anything against the government or the government, any person in government, then it was considered as sedition. But to enable article 19(1), that is the right to freedom of speech and expression and the right to life and liberty, now sedition has been taken off. Now in place of that one, section 152, acts endangering unity, sovereignty and territorial integrity of the country, that has been added under section 152. Added with that 197(1), that means if you publish anything against the sovereignty of the government or against the sovereignty of the nation, that is again punishable under section 197(1). So one of the important feature about these, the punishment related forms. See, in the IPC there were sections that states that punishment even for 10 rupee fine, 50 rupee fine, 100 rupee fine. So more deterrence. Now the fine has also been enhanced. Section 66, 67, voyeurism and disrobing of the woman, they are made gender neutral. I will explain what it means. Voyeurism means, for example, woman expects a decent kind of a privacy while changing the clothes or in the bathing and all those things. Earlier, only a male person, if he clicks the photograph or something, videography, that one, only male person could have been accused. Now both male and female can be an accused person, but the victim can only be a woman. So that is there. That is the same with the disrobing. Disrobing means, for example, by criminal force, you are asking the woman to become a nudity. So now again, if a woman does the same thing, that is also an offense. That is called as the general neutral that we are talking about, that one. So the mob lynching is the another one thing that has been added. It says 5 or more persons based on parameters like sex, place of birth, community, belief, or under the social profile or the social parameters. If somebody mob lynch, that means 5 or more persons mob lynch a person to a death, then it is punishable up to death penalty. That is under 103, which relates about the murder. But if the person does not die, it causes grievous hurt. Under 117(4), it is called as grievous hurt, and he can be given stringent punishment. And 117(3), it also says about the persistent vegetative state. You beaten up a person to that extent that he comes to a coma stage. So these are the things, that is the mob lynching that has been added to prevent the atrocities, especially by a community on one person or placed on anything. So for the purpose of grievous hurt, now the definition has also been changed. Now earlier was 20 days of continuous injury, continuous painful. Now 15 days, because taking into medical advancement that has been made. So beggary, that means forced labor, was also added as an because it is also a form of trafficking of a person. So beggary was also added as an offense in this one. Added to this one, earlier snatching of a purse, snatching of a vanity bag, snatching of a mobile, because this mobile is a very important thing. So snatching was only added by the state police acts. But now to give it a pan-India, this one, now snatching under section 304B has also 304 has added as a special offense. Snatching, anything, snatching of this one, snatching of a chain, we all see all these kind of offenses, this one. Another thing is the mischief. If you see the mischief of a government property, a person or a community or anybody has the right to make dharna or something else. At the same time, you cannot have the right to cause destruction to the public damage. Now, if any person under mischief is causing public damage, that is specially defined under section mischief in the Bharatiya Nyaya Sanhita, this one. So now I will go to the details of some of the things that are there in the Bharatiya Nagarika Suraksha Sanhita. One is the timelines, various timelines for investigation, for trial, or for even this one. See, it says further investigation has to be completed within 90 days. That means if there are two offenders, A and B, and one is proclaimed offender, up to 90 days you cannot start the investigation, but you have to bring him to the justice up to 90 days. So also arrest, 3 to 7 years of any punishment offense, you have to take the permission of the deputy superintendent of police. If the arrest to be person is arrest a person is more than 60 years of age or infirm. Infirm means mental and physically not good. In these kind of cases, you have to take the permission of the DSP, then only you can proceed to this one. So as far as some of the timelines is concerned, the discharge petition has to be filed within 60 days. Earlier what used to happen, A, B, C, D, 4 accused are there. First accused will go to trial court, then to the sessions court, then to all the forums, then B will start, then C will start, then that's why they delayed the trial to be started. Now all the accused has to file the discharge petition if they want to file the discharge petition within 60 days. That is the one thing that has been there. Even for committal of the proceedings, you know, committal of the proceedings means the lower court will commit the cases for the higher court. So in these cases also, the court itself, there is a timeline. 90 days extendable to 180 days, you have to committal the case. Because why it takes time means sometimes there are multiple accused. That's why the committal proceedings also this one. Like this, there are more than 30 deadlines, timelines in the Bharatiya Nagarik Suraksha Sanhita that will enhances the speedy investigation and the trial, and also even to give in the charge. For example, framing of the charges, 60 days is the time. Within 60 days you have to complete the proceedings of the framing of the charges. And earlier there was no timeline by how many days the copies to the accused has to be given. Now it is 14 days. 14 days, it is the duty of the magistrate to give the copies of the 14 days. Added to this one, now you need not to submit the charge sheet in an elaborate manner. Now you can submit the charge sheet in a pen drive or in the electronic means. At the same time, you can give the copies of the charge sheet in electronic, that is the pen drive, to all the accused. So that is another major thing that has been there, this one. Further, even to deliver the judgment after the last date of hearing, not more than 45 days, the judge has to deliver his judgment. Very important. If it exceeds 45 days, then he has to submit the reasons to be righted in the order sheet. Further, after delivering the judgment, within 7 days, they have to upload the copy of the judgment in that particular portal. So there is a timeline even for giving the judgment in these cases. And what happens with the mercy petition? Earlier, if you see the Nirbhaya scheme of other cases, mercy petitions, even the SLP has been declined by the Supreme Court. Even the constitutional obliges the accused to seek the mercy petition, mercy from the governor or the president. Earlier, they used to spend a lot of years together. Now, within 30 days, after the SLP has been rejected by the Supreme Court, they can have the option either to go to the president or to the governor. For example, if he goes to the governor within 30 days, then governor's office reject that one. Then within 60 days, they had to approach the president. Now the jail superintendent has the task, if there are 4 accused and only 1 accused has filing the mercy petition, then it is its duty to tell to the other accused, no, still you have the option of mercy petition. And if only 1 person only applies for the mercy petition, the jail superintendent has to send the name and addresses and the records of the other accused also. And also when it goes to the president, now the government, there is a timeline. Within 60 days, the government has to give the recommendation to the president about on the mercy petition. So after the mercy petition has been come and if the president office delays, then there is no Supreme Court or anything, no appeal against them. So you can see the timelines that has been stated, that the justice cannot be delayed and the investigation cannot be delayed and the trial cannot be delayed. And much more important thing, beyond cogent reasons, there can be only 2 adjournments now. Earlier, adjournment after adjournment, hearing after hearing. Now, with reasons recorded to be written, not opposed by the this one, then only the judge can give a next date of hearing beyond two dates. Now, everything has to be get streamlined and only 2 adjournments are been there, and that is there. Another thing, handcuff. See, there was a lot of things, even from the judiciary, legal fraternity and all. Who has to be handcuffed? Earlier, there was no specific guidelines. But now, handcuff can be done only in 2 things. A repeated offender. He is a repeated offender or escaped from our police custody. Escaped from the police custody or repeated offender. Again, what are the offenses? Offenses like organized crime, terrorist act, drug case, and murder, rape, sexual offenses, human trafficking, and offenses against state. In these offenses, if he is a repeated offender or earlier escaped from the custody, he can be handcuffed, because there was a lot of dilemma in which cases he has to be handcuffed and this one. Sometimes what happens when the trial comes, our police officers cannot attend because they have bedridden or they cannot read and write. Now it says the successor in the office can also go to the trial, this one, if the earlier person to be attend on the trial could not become, then the successor also can go to the this one public servant or witness, whoever, and also can give the this one as a witness. This is for the public servants and all. Even without causing arrest, you can take the specimen signature, voice sample, fingerprint, and anything. So the person need not to be arrested to take the samples also. In fact, the definition of the accused is also changed. The definition of victim also changed. Definition of victim means the accused need not to be formally charged. So what is the implication? To get compensation or to, as we said, the property claimant. Now the accused need not to be formally charged. Still the victim can get whatever is due is there. So trial in absentia. You know, sometimes we cannot find the accused as all. Now from the date of framing of the charges till the end of the judgment also. Of course, 90 days period is there for this further investigation for bringing back that accused. But if he is not at all present, means trial in absentia. Even in absence, the punishment can be given, the judgment can be delivered. But prefer appeal by that accused. He has to be personally present. What does it mean? For example, XYZ is there. He got out of the country. In his absence, it says State Legal Services Authority, that is the SALSA or the DALSA, will give an advocate to argue on his behalf. So that means while sitting abroad only, he cannot get all the machineries to work. He will get the lawyer, and the judgment is also come making him sentencing for the accused. Then if he want to prefer, means he has to compulsorily come to India to prefer an appeal in person. That means while sitting in abroad only he cannot do, or while absenting only he cannot do manage with all the affairs of the this one. So that is about the BNSS overall, some of the important changes that has been made. Now it comes to Bharatiya Nyaya Sanhita. See, Bharatiya Nyaya Sanhita, only two important sections have been added. Section 61, which says about the electronic and digital records. Electronic and digital records. And section 63 is admissibility of electronic and digital records, which was earlier properly known as section 65B. Number one. Another thing is that another section added, first section added is section 61. Another section is the 170, that is the repeal and the sayings. But what is the major change is that in the primary evidence, section 57 of the primary evidence, 4 new explanations have been added. What constitutes the primary evidence? Again, it relates to electronic evidence. This is the one thing. Why it is important means, because earlier section 65B certificate, I will explain what is 65B certificate. Whenever some mobile or something has been made and the primary evidence, I cannot take it originally. I took only a file or a folder out of a disk or a computer or something else, have been retrieved that one. I present it to the court, then a certificate has to be given by the owner of that record or that one, that such and such has been given to the this one. Another simple means, if you go to Tehsildar office, there are some records which are not signed. It says computer generated certificate, doesn't need a signature. Then who will testify in the court? Obviously the person who take out the printout will come and testify. So that is the section 65 is certificate. Now under section 63, that is the original 65, instead of one certificate, you have to give 2 certificates. What are those? One is certificate given by the owner of that record, who is having the owner of the data, and the second certificate has to be given by the person who retrieve the data, expert. These 2 certificates have been given. Because there was one case, Arjun Pandit versus Kailash Rao, regarding the admissibility of 65B certificate. It says 65B certificate can be produced to the court at any stage of trial. But now section 63 and along with section 61 says no. Now the 63 certificates, whatever those 2 certificates, has to be produced along with the exhibits. For example, I am taking the folder or anything in electronic means, you have to produce the certificate along with the exhibits or the whatever the electronic or the digital evidence I am giving. So this is another change that has been made in the Bharatiya Sakshi Adhinayam. Obviously now there is no cloud that whether something is applicable, electronic and digital records or something applicable, that it is not there. It is victim centric. It will take the balance way of both the accused, as I told. And one more thing, for example, a suicide happened in the district. Within 24 hours, the police has to inform to the magistrate. That means to say that now it may be suicide or murder, who knows. So the magistrate has to take the cognizance, isn't it? Complaint has been come to the magistrate. 30 days the complainant did not appear. Then why to harass the accused? You can relate. So it takes a balanced view, you can say. And you need not to produce the accused before the magistrate also. Especially when you ask for the repeated custody. That means, what does it mean? I arrested him today. Obviously, within 24 hours, excluding the time taken for journey, I had to produce with the magistrate. Now, I again seek for another 48 hours custody. Now, you need not to bring the accused again to the court. You just show that he is in judicial custody, sorry, he is in police custody, show him that one and this one. And to submit the charge sheet, no need to bring him. Just get the security from him and say that one in the court. So it takes a very balanced way of the both, very humanistic, very regard this one. Obviously the words earlier, lunatic, idiot, insane, these were there because these were the laws made by the English made laws. Those laws were taken off. Now more Sanman Janak, very respectable words like acute illness, these words are added in place of idiot, lucine, or all those things. So many changes have been brought in the 3 criminal laws. So I rest my case. Thank you so much for patient listening. Thank you so much.